George Hawkins was a young man of 11 when his hand was scarred pretty seriously from contact with an electrical wire after turning on the light switch in his family's home kitchen when he was 11 years old. Later, he sued for a breach of contract in 1926. Who did he sue? He sued the defendant, Dr. McGee. Dr. McGee had taken a skin graft from Hawkins' chest area and put it onto his hand area and told him, this is the way to go, this will take care of everything. As a matter of fact, what he did say, apparently, was that the boy would be in the hospital for a few days, then he'd go back to work with a good hand. That the court looks at as a statement of opinion rather than a statement of actual fact that could have been relied upon in a breach of contract suit. However, for the breach of contract, the court looks to the basis for plaintiff's claim is the testimony that the defendant also said before the operation had been decided upon, quote, "I will guarantee to make the hand 100% perfect hand or 100% good hand," close quote. If those words were uttered, the court says, this would establish a claim for warranty, or in our words, a claim for breach of contract. A warranty is a promise. In this case, the alleged promise that Dr. McGee would provide George Hawkins with a 100% perfect hand or 100% good hand. A breach of warranty is a specific form of contract breach where a provider's guarantees, promises about a product, a service, or the outcome of contracted for events prove to be inaccurate. A breach of that term may be a breach of contract. It seems that the doctor was actually experimenting on skin grafting using George as his lab rat. Maybe I'm going too far, huh? But it turns out that he had little previous experience on this and on skin grafting. The jury was then allowed to consider two separate elements of damage. It was allowed to consider, 1, pain and suffering due to the operation, and 2, positive ill effects of the operation upon the plaintiff's hand. So the case went to the jury. The jury found against the doctor and in favor of George Hawkins. This Supreme Court of New Hampshire in 1929 says, erroneous instructions. And then it goes on to explain why the instructions are erroneous. It starts with a definition of damages. As that term is used in the law of contracts, it is intended to serve as compensation for a breach measured by the terms of the contract. And the purpose of such a law of damages, such a rule, is to put the plaintiff in as good a position as he would have been had the defendant kept his contract. Now, we know that, expectation damages, but the court goes on to recite some mystifying area of the law. It says, according to Williston on contracts, quote, "The only losses that can be said fairly to come within the terms of a contract are such as the parties must have had in mind when the contract was made, or such as they either knew or ought to have known would probably result from a failure to comply with its terms." Well, It's not real easy to understand, but the court goes on and explains what it means by telling us that the true measure of plaintiff's damages in this case is the difference between the value to him of a perfect hand or a good hand, such as the jury found the defendant promised him, and the value of his hand in the present hairy condition, including any incidental consequences fairly within the contemplation of the parties when they made the contract. The court refers to that as a limit, a limitation on the damages. That's it. Specifically, the court looks at the claim for pain and suffering and says, no, the pain and suffering was as a result of the operation. It wasn't as a result of the breach. He knew he was going to go through some pain and through some suffering, and that was part of the deal. So you're not getting any damages for that. The court makes what I consider to be an unusual statement in our time, but apparently not way back then. Listen to this. The pain necessary to reach the desired result was a legal detriment suffered by Watkins, which constituted a part of the consideration given by him for the contract. Well, I turn now to a footnote in the work of Brian Blum and Amy Bushaw, who have written a fine contracts textbook. And this footnote says the following, and I'm quoting it. This statement bears further explanation, as conventionally it would appear to be an incorrect statement under consideration doctrine. Although undergoing an operation and suffering the attendant pain is undoubtedly a legal detriment, in the usual case it would not be bargained for, and thus could not constitute consideration. Although a doctor's promise to cure might induce a patient to undergo an operation, as here, in the usual case, we wouldn't expect a doctor to be induced to cure a patient in order to see the patient suffer. Here, however, as the court alludes to the fact that Dr. McGee may have had a particular interest in persuading George Hawkins to undergo this experimental surgery, one could argue that the patient's willingness to undergo the surgery and suffer the attendant pain did induce the doctor's promise to cure and vice versa. Close quote. That makes sense. It makes sense out of what seems to be something that doesn't make sense. The true measure of the plaintiff's damage in the present case is the difference between the value to him of a perfect hand or a good hand, such as the jury found the defendant promised him, and the value of his hand in its present condition, including any incidental consequences, fairly within the contemplation of the parties when they made their contract. Why wouldn't the proper measure of damages in this case be the difference between the value of what Hawkins began with and the hand he wound up with? You'll notice a couple other things about the case. It sounds like the doctrine of foreseeability that you have encountered or will encounter in torts class when the court refers to any incidental consequences fairly within the contemplation of the parties when they made their contract. It's interesting to relate the foreseeability concept of torts to this incidental consequences fairly within the contemplation of the parties. Also, this is interesting. You may wonder about this. There is no mention in the opinion, at least as I've read, of the need to establish damages with reasonable certainty. Given what we've gone over, are you able to articulate precisely what might establish that value with reasonable certainty. I'll refer you now, for further reading if you care to a relatively recent article, 2011, which goes through the reasoning and some of the common wisdom surrounding the parties and the case, and concludes, based on an extensive examination of the trial record, that much of what you read in the case is either mistaken or overstated. I'll put the citation right after this video, so watch for it.